And now for another update, this one on recent Texas legislation. Signed into law on May 19, 2025, and effective September 1, 2025, Senate Bill 1057 is a new law aimed at nationally listed corporations, which are corporations that 1. Have a class of equity securities registered under Section 12B of the Securities Exchange Act, 2. Are listed on a national securities exchange, and 3. Are either headquartered in Texas, listed on a stock exchange that is headquartered in Texas, or have received approval by the Securities Commissioner under Subchapter C, Chapter 4005 of the Texas Government Code. Additionally, to be subject to 1057, a nationally listed corporation must opt in to the SB 1057 by making the specific election to be subject to it through an amendment to the governing documents of the corporation. With its multiple requirements for qualification and elective applicability, SB 1057 is a very specific law designed to grant eligible corporations in Texas options to adopt stricter rules on which shareholders may submit proposals at shareholder meetings, limiting the influence of smaller investors. Under SB 1057, to submit a proposal at a shareholder meeting to be brought forward for shareholder approval, a shareholder or group of shareholders must 1. Either own voting shares equal to $1 million in market value, or 3% of the corporation's total voting shares. 2. For 6 continuous months before and throughout the shareholder meeting, and 3. Solicit the votes of shareholders representing at least 67% of the shares entitled to vote on the proposal. Lists and qualifiers aside, what does this law actually do? Well, to put it simply, SB 1057 allows corporations with numerous shareholders to keep shareholder meetings focused on material business. By restricting the requirements for shareholder proposals and voting brought to the table at shareholder meetings, SB 1057 aims to make Texas a more attractive venue for the incorporation and listing on stock exchanges and compete with Delaware as the hub for U.S. companies. Restricting what is brought to and voted on in shareholder meetings will, in theory, give management more control of the corporation and reduce potential disruptions in corporate business caused by smaller shareholders. Texas corporate law is rapidly developing, and as more corporations elect to opt in to the restrictions of SB 1057, we can expect to see more bills empowering management to act in the corporation's best interest, even if that comes at the cost of the rights of smaller shareholders. For now, SB 1057 is here to stay, but be sure to stay tuned and follow RRNA for the latest news and developments in Texas corporate law. I'd like to thank Siam Rahman, a junior associate in our Houston office, for his help on this update.